Sometimes the story isn't really about what went down, but how it all unfolded. We're about to deconstruct a case file where, honestly, every single document just seems to ask more questions than it answers. Okay, let's dive into this.
So let's just jump right in. It all kicks off with a phone call. Imagine you're at home, and that's what a police officer is telling you from the other side of your door. There's no negotiation, no discussion, just a flat-out threat. The tension is there from the very first second.
And then they say it again, but listen really closely to that justification they tack on at the end. To make sure people are safe. That phrase, ensuring safety, becomes the official reason for absolutely everything that's about to happen. Remember that, because it's going to come up again.
So what's their justification for all this? A 911 call, one that came from a phone registered to the house. And for the police, that's it. That's all the authority they need to demand entry, even if it means breaking down the door. But to really get how we got to this point, we need to rewind 2 years and start digging through the paperwork.
Right, so this whole confrontation wasn't just a random event. It's actually the climax of years of confusing legal notices, warrants, and just a mess of documents, all tied to this one single file, 45248.
Okay, this timeline is where things start to get really weird. It all starts in June 2023. An RCMP officer issues a document on the side of the road for a serious criminal charge, uttering threats. A court date is missed, so a warrant gets issued. A year later, it happens again. Another missed court date, another warrant. And then, exactly 2 years after that first document was issued, there's a raid. And get this, the police say they're there because of a warrant for that original criminal charge. Just keep that in your back pocket, because it's a massive piece of the puzzle.
But here's the twist. A critical piece of information buried in the court file that changes, well, everything. After the RCMP handed out that first notice, the file went to a Crown prosecutor who looked at it and decided not to go forward with the criminal uttering threats charge. Instead, they downgraded the whole thing to just a peace bond.
And that brings us to the million-dollar question of this entire case, right? The piece of paper from the police on the roadside said one thing, a serious criminal charge. But the actual case in the court system was something else entirely. So was the person ever officially told about this massive change? The file gives us no clue.
So to try and get some answers, the person in question starts making calls to the court registry, trying to figure out what the correct procedure is. But instead of clarity, what these calls reveal is a system that seems designed to be confusing.
So the first call is to the court registry, which is the one place you'd think could give you a straight answer. And this is what they say. It's basically, don't ask us how it starts, we just handle the very end. It's just an immediate, not my department.
And from there, it's a total wild goose chase. First, they say, call the police. Then, oh, you should talk to the Crown. Then, maybe get a lawyer. And finally, after all that, a manager says the best person to talk to is the criminal desk clerk. The first person they spoke to. It is a bureaucratic nightmare.
Okay, let's just pause for a second and define what we're even talking about here, because this distinction is absolutely crucial. A Section 810 peace bond is not a criminal conviction. It's a preventative court order. It doesn't mean you've been found guilty of a crime. It just means a court is ordering you to stay out of trouble because someone else says they're afraid of you.
So after all that back and forth, a manager at the court registry finally lays out the official, by-the-book procedure for how a peace bond is supposed to work, straight out of the criminal code.
Now look at this process. It all starts with a sworn application that goes before a judge, a justice of the peace. And crucially, that judge has to review the case before anyone is even ordered to show up to court with a summons. An arrest warrant, that's the absolute last resort.
All right, so that's the official playbook, with all its checks and balances. Now, how does that compare to what actually happened in File 45248? Well, the difference is pretty staggering.
And here it is. This is the core of the whole problem. The official legal procedure starts in a courthouse with a judge looking at evidence. But in this case, it started on the side of a road with an RCMP officer handing out a piece of paper. In the playbook, a judge issues a summons. Here, the police document just takes its place. The entire judicial review step, that first critical safeguard, it just seems to have been skipped completely.
This is a question that was actually asked during one of those calls to the court registry, and it gets right to the heart of it. If the law says this whole thing starts with a judge, how can the police just kick it off on their own with a roadside notice? The registry clerk had no answer. They literally just said, you would have to ask the RCMP how they have the power to do that.
The numbers in the file pretty much tell the whole story. The number of official court-approved summonses? 0. The number of roadside undertakings issued by police? 2. And the number of arrest warrants that came from those? 2. The one single document the criminal code says you need to start this process is just nowhere will be found.
And it all comes to a head on June 2nd, 2025. 2 years to the day after that first roadside stop, the police conduct their raid. And their justification? A warrant for uttering threats. The exact same criminal charge that the Crown had decided to drop 2 years earlier. It's like that decision never even happened.
So what are we left with here? We've got two completely conflicting versions of justice. One is written down in the law, with clear steps and safeguards, and the other is a process that starts on the roadside, totally driven by police. And that leaves us with a really fundamental question that goes way beyond just this one case file. When police authority and the actual law conflict, which one ends up winning?